Welcome, everyone. My name is Kara Ockendon, and I am a relationship, separation, divorce coach or soul healing. I specialize in conscious relating and conscious uncoupling as you're moving through relationship breakdowns, whether that be before separating, during separation and divorce, or post separation. That said, I'm extremely passionate about taking a holistic approach to transformation and uncoupling, whether that be uncoupling from your relationships or relationship patterns as well. And for me, I think it's incredibly important to have access to all the right tools and resources that you may need as you're moving through this process so you can move forward with the most ease. And with that today, I'm going to be speaking to Kate Redman, who is a solicitor that was admitted to the Queensland Law Society in 2013. Kate Redman is a succession lawyer. For those of you who don't know what that is, that's someone who is involved in assisting people with estate planning. Kate herself is extremely passionate about working with young families and also those who may be moving through estate disputes on either side of that dispute. And by that, I mean, after someone who has passed, sometimes there is a dispute between those who remain living around the estate and what's to happen there. And she's very passionate about that too. Kate is notably accomplished in her ability to demystify the process of estate law. She prides herself on being able to take the jargon out of law and help those to move through the process of estate planning in a less intimidating way that's far more clear and easy to understand. She's committed to guiding her clients through making difficult decisions regarding their estate plannings and has earned a reputation for being compassionate and highly skilled. She is here today to talk to me about the importance of estate planning as you move through relationship breakdowns and struggles. So with that introduction, I'd now like to give a very warm welcome to Kate, who's here with me today. Thank you so much for joining me, Kate. It's so lovely to have you.
Thank you for having me. This is very exciting.
Yes. So, yes, as I was saying before, we're going to be speaking into your role as an estate planning lawyer. So, Kate, would you tell me a little bit about you as a person and how you got yourself into law?
Sure. So I was admitted as a lawyer in 2013. I can't believe that it's been that many years. It feels like the time's just flown by. So I'm a mum to two young boys and I've been married nearly 10 years and I practice in estate planning, estate administration, estate litigation. So everything in that space is what I'm here to help clients with.
Wonderful, wonderful. And can you tell me a little bit as well in terms of the services that you help people with in estate planning? So, I mean, a lot of people don't even really know necessarily what it's entailed as they never step foot in a solicitor's office or a legal office. So perhaps if you could give just a little basic info for individuals who might not know what it actually means to do estate planning.
Oh, of course. So I help people to make sure that when they pass away or lose capacity to make their own decisions, their loved ones will be looked after and their wishes will be carried out. So I draft wills, enduring powers of attorney, advance health directives, and I also work with accountants and financial advisors to make sure that in the event my clients pass away unexpectedly, their estate can be administered as smoothly as possible so that their loved ones can focus on the grieving process. So basically your estate is what's left of everything you own once any debts have been paid from your estate. And the good news, or I think it's good news anyway, your HEX debt doesn't need to be paid out from your estate. So it's a question a lot of people have, especially in this age of very big HEX debts. People worry that they're not going to have anything left to leave their loved ones once HEX is paid out, but your HEX debt is forgiven if you pass away.
Yes, well, thank you for sharing that because I wasn't aware of that either. So in terms of, can you speak a little bit more then into your enduring power of attorney and advance health directives? So what's the purpose of those two particular documents and why is it important for people to have them?
So estate planning is important because you've got your will, which is the document that dictates what happens if you pass away, and your enduring power of attorney is what happens if you're still alive, but if you've lost capacity. So a lot of people think of the enduring power of attorney as the kind of had a stroke or in a coma document. So it's the document that gives power to someone to make financial decisions, and also it can be either that person or a different person who can make personal and health decisions on your behalf. So your financial power of attorney would be making sure your bills are paid. They might be applying for any super, total permanent disability insurance to be paid out, any of that sort of stuff. And your your personal and health attorney would organise things like if you needed to go for rehabilitation, they'd choose which facility that would take place at and choose which hospital you might be staying at and all of those sorts of things. So they can be the same person or they can be two different people.
Right, thank you. And at what points should individuals maybe be looking to look into estate planning? Like, when is it important? What times in your life? I mean, a lot of people tend to not really like to think about it because it means awful things, death and being incapacitated, right?
Yeah,
but
exactly.
at what points and times do you recommend that individuals, maybe particularly, and maybe more important for people to address their estate planning or revisit their estate planning?
Yeah, so everyone over the age of 18 should have a will and an enduring power of attorney. The rules have changed so that from the age of 16, if you're working 30 hours or more per week, you must be paid superannuation. And with most superannuation funds, you have a death benefit tied to that super account. So you could have the case where, you know, a 19-year-old could pass away and actually have an estate worth a couple of $100,000 just because of any death benefit paying out. The times when it would be really important, particularly to revisit your estate plan or to make one in the first place, is if you are in the middle of a relationship breakdown. So the reason why I say that is that you can have the case where you currently have a will that appoints your spouse, so your either your married spouse or your de facto spouse as your executor and the beneficiary. And although divorce or the breakdown of a de facto relationship will revoke those provisions of your will, it's important to note that before a divorce is finalized, that will is still valid even if you're separated. So sometimes people can be separated for years before divorcing. I actually have a friend whose parents have been separated for well over 20 years and haven't divorced. That will is still valid even if you are separated. And if you lose capacity or pass away and that spouse is still appointed under your will or under your enduring power of attorney, then they can still act as executor, they can benefit from your estate, they can make decisions on your behalf under that enduring power of attorney. So that's why it's extremely important to have a new will made and to instruct your lawyer that it's important that it's made in contemplation of your divorce and that specific wording that needs to be included in the will, so that if you pass away, it's clear that you made the will in the context of your divorce and that you don't wish for your spouse to be executor or benefit under your will. You'll also need to review any superannuation binding death benefit nominations that you've made to ensure that you don't unintentionally direct your super fund to pay your benefits to your ex-partner if you pass away. And it's also very important to revoke any enduring power of attorney appointing your spouse for financial or personal health matters if you don't wish them to act for you in that capacity anymore. That's a formal process that it's best to speak to a lawyer about.
Yes, 100%. And it's one of those things that can be, I know in my experience when I was practicing family law, can be quite complex if it's not addressed. I mean, particularly if you're dealing with property that may also be in joint tenancy and the like, and things can get a little bit messy and confusing. Like I remember one case that we had where the client had not addressed their estate matters, despite advice to do so, as we would have always advised our clients in family law, and unfortunately passed away. Young, very tragic, young woman, young children, but unfortunately in that situation, her house defaulted to her estranged husband, and her estranged husband, for whatever reason, did not want to have that go to the children. So there was big complexities there, and it does become incredibly important to at least consider what you want in that situation, because yes, some people may actually want their estranged spouse to have something to look after the children, or the structures you can put in place for that to happen, depending on their circumstances, but a lot of people don't, right?
And that's the thing with property owned as joint tenants, is that actually doesn't fall into your estate. So that takes that transfer happens automatically, and that's outside of your estate. So that's outside of your will. You don't actually have power over, if you own a property as joint tenants with somebody, that bypasses the estate and it goes straight to that person. So you'd really be wanting to get some legal advice about how to manage that if you were in the midst of a relationship breakdown and you didn't want your share of that property to automatically pass to that spouse.
Absolutely. And it's something that's critical to do sooner rather than later in a relationship breakdown, because of those reasons that you just don't know what's going to happen. As much as we think we're immortal, and particularly if you may be a young family separating, it's certainly probably not high on your priority list, but it is important. The other thing I did want to touch on here as well is around, I suppose, other family challenges. So individuals who may have relationship breakdowns in other relationships that may not be romantic. So this could be with your children, where you may have an estrangement from your children, or anyone else in your life who may be dependent upon you, that may have entitlements to your estate. So that's something that I thought I'd just touch on as well, because I think it is important to recognize that when we're having relationship challenges, they're not always just with our spouse. So sometimes our children can be sources of heartache as well. So Kate, we can touch on that.
Yes, of course. So, and just to preface this, everything I'm talking about today is for Queensland estate law only. So estate law is state-based in Australia. It's not like family law that's federal. So everything that I'll be touching on here is about Queensland law only. There are a lot of myths about estate planning and wills generally, and about the capacity of different people to challenge your will if they're unhappy with it after you pass away. Every situation is different, but in the case where you are concerned that someone with perhaps a strong claim to challenge your estate is in the mix, my priority would always be to discuss that with you in depth, and to be looking at ways that you could ensure that your wishes are carried out with the least risk possible for someone to be able to make a successful claim on your estate. It's also very important that people realize that just because a new partner isn't living with them and doesn't have shared bank accounts with them, they're still able to make to challenge your will. I have seen it happen before, that a man left his estate to his two children in equal shares, and his girlfriend was able to successfully challenge his estate and to receive a benefit from the estate. They did not live together. They didn't have any shared finances, but she was able to show that she had meaningfully contributed to his property through things like helping him build a retaining wall in the backyard and supplying groceries from time to time and that sort of thing. So it very much is on a case-by-case basis. It's not something where you can make sort of broad sweeping claims about guarantees and all of that sort of thing. I'd love it if I could provide guarantees that your wishes will be carried out to a T no matter what they are, but that's where it's very important to get advice from someone who knows this area of the law and who can advise you accordingly. And there are different structures that you can put in place with different risks and different costs, but it isn't the case that that your wishes will always be carried out or that they'll never be carried out. It's on a case-by-case basis.
Yes, as is always the case in any law, and if you're moving through family law, no one can say you guarantee the outcome, much to a lot of people's surprise sometimes when they're not so informed about legal processes. Some people don't even realise that their wills can be challenged, and by whom. I suppose that brings me to my next point or question, and I suppose also the importance of revisiting your estate planning, not just when you separate, but again when you repartner, because then you've got extra challenges of having perhaps blended families and all of that coming into the mix. And again, there are certain things that you can do to support what you're wanting to bring into fruition. However, again, of course, there's caveats on that, individuals, you can't stop making individuals who have an entitlement to claim of making a claim. All you can do is put in structures that reduce the risk of them being successful in that. So, yes, I'm so glad that you touched upon that. And yes, do you have anything more to say around that situation where perhaps even then there may be stepchildren that also could have entitlements and the like?
Yeah, so stepchildren are considered children for the purposes of the Succession Act. So they In
which is for some
Queensland?
reason.
Yeah,
There's probably fairly similar laws across Australia, but not precisely the same. So
yes, and I don't
yeah.
want anyone in New South Wales to be taking what I say at face value, because New South Wales, as in so many areas of the law, does things very differently. You'd be wanting to speak to a New South Wales or state lawyer about any of these issues, but it sounds callous, but I would really recommend obtaining advice as soon as possible after repartnering, rather than waiting for things to possibly sour, because you don't know what's going to happen, and you don't want to be in the position where the relationship has already started breaking down and then you're getting some estate law advice. I mean, I can obviously still help in that situation where a relationship has started breaking down, but it's best to seek advice as early as possible after repartnering. Something that is a real misconception that I've noticed in the community is that people seem to believe that the guardian that they choose for their children doesn't have to be the child's other biological parent. So I've seen it happen in many cases where people are saying, but I want the guardian of my children to be my current partner. I mean, we've been together since my kids were little, and my previous partner never sees the children, and it should be my current partner. And unfortunately, that's not the case. The biological parent, the other biological parent, will always have the sort of the first claim to be guardian if you were to pass away. So you can state your wish for your current partner to be their guardian, but if their biological parent is still alive and able to be contacted, they will have the first right to be guardian of the children. But they can obviously give up that right, but then that would mean that the guardian that you've appointed under your will would be able to take over. But that's a bit of a formal process of having a biological parent step away and all of that sort of thing. So that is something that I see as well, especially with a particularly acrimonious breakup, is people want to be able to appoint their own guardian, even if the ex-spouse is still alive. And unfortunately, that's not how it works.
And that's a highly complex area of sort of family law as well, when you're talking about rights of perhaps step parents who may have been very significantly involved in children's life, and even step grandparents and all of these things. It becomes incredibly complex, I know from my experience of family law. So if you do fall into that category, like post someone's passing, then it's something that you would definitely need to get specialized legal advice upon. I would just preface that, because it's highly complex, and but there are avenues to move forward in that. If you are that step parent who has had your partner pass away and you have step children that you would like to still have in your life. Whole other area of law and a whole other area of complexity, but certainly I think what's really crucial to really drive home here is that no matter where you're living in Australia or even the world, is that estate planning is crucially important to be visited at, well, I suppose when you're first able to have an estate, which you're now telling me is 16, which I was not aware of, with superannuation.
So you can't make a will you can't make a will until you're 18, but you can start being paid super from 16 if you're working 30 hours or more per week. So
yes.
Sorry to jump in. I just wanted to make sure that no one thought that I was saying 16-year-olds need to have wills. They're not legally able to.
Thank you. Thank you for clarifying that. So so from the age of 18, and then again, you want to revisiting it at these crucial points in your life, when you're getting married, when you're getting divorced, when you're repartnering, or any time when there's significant changes in your circumstances in life. There's various points where this becomes critically important if you want to have your wishes, or have a chance of your wishes being, successfully followed through at the event of your passing, or even when you're incapacitated. If you're wanting to have the person that you most trust handle that situation for you, whoever that may be, whether that's your spouse, your children, trusted friend, or the like. So yes, I think, that's been really, really helpful, Kate, all that information. Is there anything else you'd like to add there around estate planning in relationship context?
So just from my point of view, so estate planning is a real passion of mine. I think of myself as your trusted advisor who gets all the kind of unpleasant work done in the background so that you can just focus on your life and your relationships. So the way I work with clients is that we make an appointment to discuss your estate plan, and in preparation for that appointment, I give you an information sheet and a questionnaire. You don't have to complete the questionnaire before our appointment, but it does provide a guide as to what kind of questions I'll be asking and what I'll need to know from you. Then we have your appointment and I take your instructions and then let you know what I recommend for your estate plan and provide you with quotes about different options. So that appointment is free and can be done in person at my office, at your work, at a cafe, anywhere that's convenient for you, or it can also be done virtually. And I'm happy to make myself available after hours, on weekends, to fit in with you. So I know what it's like to try to find time in your very busy life for these sorts of appointments, especially because it's not a particularly pleasant thing to be thinking about. So that's why I aim to make it as easy as possible. And I look to talk to you in simplistic terms. I don't charge per question. You can ask as many questions as you like. I do my work on a fixed fee basis, so you don't have to worry that every time you pick up the phone to talk to me that I'll be adding more money to your bill. This is a real passion area of mine, and it's something that I really love helping people with and making sure that your wishes are carried out, and that it won't be that if you don't have a will, then your estate will be administered according to the intestacy rules and the Succession Act, which I've never seen a will made that is in line with the intestacy rules. So people always want something different from the intestacy rules with very good reason. So that's what I aim to do, is to save you from your estate being administered according to the intestacy rules.
Yes, thank you, Kate. And whereabouts are you servicing? Are you servicing all of Queensland or just around Brisbane? Like, what's your service area?
So I see clients in person from the Sunshine Coast down to the Gold Coast, and then everywhere else virtually.
Virtually in Queensland.
Yes. In Queensland. Right. I can't. Yes.
In Queensland. Thank you. And whereabouts are you based now in terms of your legal practice? The firm that you're working at currently?
So I'm with Kilmartin Nivette Lawyers, and we are in Brisbane CBD at 239 George Street. So right in the legal hub of the CBD near the courts.
You don't have to go to the CBD to see Kate, everyone, just so you're aware. It's not necessary.
No, so I usually see clients away from the CBD. I've had an appointment this morning at a cafe. So happy to go to wherever is more convenient for you, wherever you feel comfortable, because I don't want this to be scary or arduous. I'd like it to be as easy as possible. So, yes, and I love it when clients say, oh, this is so easy. And I go, yes, exactly. I'm so glad you think so too.
Yeah, that's easier than the family law side of things. I can assure you, doing the estate planning, Kate's the easy part. So anyway, I'll just note that the other part of your family law planning is going to be, well, getting out of the separation is much more challenging, but Kate can make this part at least easy. So thank you so much, Kate, for being here with me today. I really, really appreciate your time and your knowledge and your wisdom that you've been sharing with our audience here, and I really hope you have a brilliant day.
Thank you. You too. Thanks for having me.
Thank you.